We're live.
Okay. Good evening and welcome to the April 11th, 2022 regular meeting for the New Albany Plain Local Board of Education. Ms. Jenkins, please call the roll. Mr. McClelland.
Here.
Mr. Darrow.
Here.
Mr. Bush.
Here.
Vice President Newhoff.
Here.
President Kalinowski. Here. Please stand for the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Superintendent Sawyers, are there any additions or corrections to tonight's agenda?
None, thank you.
With none, may I have a motion and a second to approve tonight's agenda?
So moved. Second.
Mr. Newhoff, Mr. Darrow, Ms. Jenkins, please call the roll. Vice President Newhoff.
Yes.
Mr. Darrow.
Yes.
Mr. Bush.
Yes.
Mr. McClellan.
Yes.
President Kalinowski. Yes, and the motion carries. Next on our agenda is board recognition. Superintendent Sawyers.
President Kalinowski, Vice President Newhoff, members of the Board of Education, we have a unique opportunity this evening to recognize one of our own. I'm going to invite Mrs. Smith, our primary school principal, to the podium to introduce and welcome and publicly congratulate and explain the Presidential Award for Excellence in Mathematics and Science Teaching that has been awarded to Christina Pratt. We also have with us this evening Representative Mary Lightbody from the General Assembly, who will also be speaking after Mrs. Smith. Mrs. Smith.
Good evening, Board President Kalinowski, Vice President Newhoff, and members of the board. It is with great pleasure I share with you about the national recognition earned by one of our staff members at New Albany Primary School. Chrissy Pratt has received the Presidential Award for Excellence in Mathematics and Science Teaching, an honor this year held only by 2 teachers in Ohio and 117 educators across America. This award, coordinated by the National Science Foundation on behalf of the White House Office of Science and Technology Policy, recognizes outstanding teachers for their contributions to the teaching of science, technology, engineering, mathematics, and computer science. Mrs. Pratt joined my staff in 2015 as a 3rd grade teacher. Prior to New Albany, she served as a classroom teacher and a special education teacher. At my school, Mrs. Pratt served as a teacher mentor, a community leader, and on numerous committees, including my STEM leadership team and our R-Factor team. Her leadership skills at the primary school were also recognized by the Ohio Department of Education, which included Mrs. Pratt on their Ohio Computer Science Standards Writing Committee in 2018. I was contacted by the Teaching and Learning Collaborative in 2020 to inquire if Ms. Pratt could temporarily serve as a statewide professional development specialist. When she returns to my school, she will bring a wealth of knowledge for her time at the Teaching and Learning Collaborative to benefit our students and staff. Mrs. Pratt will also receive a certificate signed by President Biden and will travel to Washington, D.C. for an awards ceremony at a future date. It is my pleasure and my honor to introduce Christina Pratt.
Representative Lightbody is here, so we'll allow her to speak before Christina comes to the podium.
Thank you very much, Dr. Sawyers. Good afternoon or evening to you all, and thank you for allowing me this opportunity to share a little bit of news. I know quite a bit about this award because I tried to get it in the years when I was teaching science in the Columbus City schools, and I ended up as a runner-up. So it's a terrific award. It really means a lot to the state that you all have a presidential award winner for this particular award. And also I should tell you that I also worked at the Teaching and Learning Collaborative back in the day. And so I know quite a lot about that opportunity as well. So what I have is a commendation for Ms. Pratt, which says in short, among 102 educators across the nation acknowledged as an outstanding mathematics and science teacher, 2 of them from Ohio, you can be justly proud of this prestigious award. And that's all I'm going to say. You can, she'll read the rest of it.
So you want to come back up?
Yeah, please.
There we go. Even better. Congratulations. Thank you very much.
Thank
There's
you.
for you. Now I'm going to listen to your remarks.
All right. Actually, in 2019, 5 of my students and I got to meet you at the State House for Computer Science Advocacy Day. So I was excited to hear that you would be here for that. So thank you for giving me the opportunity to publicly celebrate this accomplishment. After waiting 2 years to hear about it on top of a pandemic, it has been quite a wait. So thank you. I won't take up too much time. If you know me well, it's not because I don't have a lot to say. It's because I'm really not in much of a position to stand up here for very long. So I grew up on the west side of Columbus, and I'm a proud Columbus City Schools graduate. And I knew from the time I was a 2nd grader that I wanted to be a teacher. Throughout my K-12 journey, I was fortunate enough to have teachers of many who saw something in me that at the time I didn't see in myself. They pushed me, they encouraged me, and they made me feel seen. I went on to graduate from Heidelberg University, and at the time, teaching jobs were impossible to come by. And although I wanted to be back in the Columbus area, I stayed there for 4 years and taught special ed and then 2nd grade until I made my decision to try to move back to Columbus. My first introduction to New Albany was through an interview with Scott Emery in 2015. And this was the first interview I had that never felt like an interview. And if you know Scott well, you know why that is. Our meeting was very close to the deadline for me to get out of my contract that I was currently in. And I'll never forget, he said something along the lines of, if this isn't approved, do you think your district will let you out of your contract? And I thought, I don't know, why wouldn't they? And he said, well, you seem very valuable and it's probably going to be hard for them to let you go. And I remember thinking, I never even considered that. That someone might not want me to leave because of the value that I could bring. And Scott didn't end up having a position open, but he passed my name along to Teresa as well as Sheila because I was special ed certified. And Teresa ended up hiring me, and the rest is history. But during that initial meeting, Scott saw something in me that I didn't yet see in myself, just as many teachers did throughout my learning journey. And I want to be clear that not only did these people see something in me, they verbalized it. This taught me something very early on, that our words matter. And when I reflect on this award, I keep coming back to how much our words matter and how important it is to make students feel seen.
And not just the students whose test scores go onto the state report card, because we know that not every student is reflected there. Not just the students with whom we relate to, and not just the ones with whom our beliefs align, but every student every single day. So thank you for giving me the opportunity to share my words here tonight about what I think has impacted me the most. It wasn't an AP course, of which I took many, and I don't remember a lot from my teacher education program, but what I do remember were the moments when someone was willing to say out loud, "You are special," instead of assuming that I already knew. And I must admit that the 300 hours of professional development did help along the way too. So to Scott, Katie, who I also worked for, and Teresa, thank you for always making me feel seen, trusting me to take risks, even when it looks a little messy. To the board, Lori and Michael, for working hard to do what's best for kids so that the rest of us can do what's best as well. And most importantly, for the parents in New Albany who trusted me with their kids every single day, even when it looked non-traditional and when it looked messy. They let me be the expert that I am, and really that helped me to grow as well. So thank you all very much.
Congratulations again, Ms. Pratt. We're very proud of you and everything that you do on a daily basis, and we look forward to your return to the classroom to continue to help our students achieve, learn, and grow every day. So, you can escape. You do not have to.
I already did run it by Pat.
For the remainder. It's really okay.
Congratulations.
Congrats.
You can't escape. It's okay.
All right, next on our agenda is an opportunity for public participation. Do we have any participants this evening? No. Okay, we will move on to discussion items. Our first discussion item is a legal update. Superintendent Sawyer.
Members of the Board of Education, based on the conversations with President Kalinowski, we had planned for various topics in lieu of a board retreat. So one of them that was requested was a legal update. Bill Dieters is here from NS Britain as our legal counsel on the personnel HR dominant side of the house. In our school district, for general counsel purposes across everything in the school district, typically with the exception of special education, which is handled by a different firm. Mr. Dieters is here in person to provide you with the legal update. He's going to explain that it's meant to be interactive, I believe, based upon the prep that we've done. So if he wants it to be interactive, he'll give you information, but is happy to entertain questions, I think, as he goes along through his presentation. Mr. Dieters.
Well, first of all, that's kind of a hard act to follow. So that's pretty
Why
amazing.
she's the presidential award.
Yeah, the only thing I ever had signed by a president was my enlistment document for the Army, so that's about all I got. Yeah, I think what Michael said is really important. I don't want to just talk at you today. I really want to have the opportunity to engage in some conversation. So we kind of have a list of some legal updates or some important things for the board that I think are good for the board to know. For some of you, it may be things that are nothing more than reviews. For some of you, it may be some new information or some twist on some new information. So essentially, we're going to cover some issues regarding Ohio Sunshine Laws, which is the Open Meetings Act and the Open Records Act. I'm not going to go into an exhaustive, 4-hour presentation on it. We're going to hit some of the most vital elements for you as a Board of Education, I believe, on those issues. I'm going to talk a little bit about some levy do's and don'ts as it relates to whether you have a PI levy or operating levy, kind of what there have been some districts who have gotten in trouble in the last few years on some levy issues related to spending public funds with levies. We're going to talk a little bit about some other just kind of various topics. I have some court cases that have occurred really in the last couple of years that I think are of some importance to look at. There are some transportation issues and then some issues related to some new holidays that the legislature has identified. And then lastly, we'll look at some Title IX things as it relates to sexual harassment and then some transgender issues as well. So feel free to ask questions whenever you want. I don't have any problem with that. I'd rather, again, engage with you in any way I can to make it as conversational as possible. Let's first talk a little bit about Ohio Sunshine Law. What a lot of people don't realize is that Ohio's sunshine laws are made up of the Open Records Act and the Open Meetings Act, but Ohio, in comparison to the federal laws and many other states, probably has, however you want to characterize it, the most transparent, the most liberal, the most open as it relates to open meetings and open records. If you would take our Open Records Act and compare it with many other states like Indiana, for one, a neighbor, or the federal government as it relates to the Freedom of Information Act, ours provides a much more extensive ability to access records and much more obligation as it relates to the maintenance of those records. So as we're looking at these things, let's first talk about meetings. So under Ohio law, there are basically, you can have a regular meeting, you can have a special meeting, and you can have emergency meetings. Your regular meeting as a Board of Education would be those meetings that you identify at the beginning of the year in your organizational meeting, usually in January, and you schedule those meetings. Those are regular meetings, and they have some important things to them that we're going to talk about in a second. You also have special meetings. Special meetings are those meetings which are not regularly scheduled. They can be called, typically your board policy will address it, but they usually can be, your board policy, I believe, probably says it can be called by the board president, or they can be called by 2 other board members in consensus. A special meeting has to have at least, and this 48 hours notice for you as board members and 24 hours notice for the press. And that's kind of a little nuance, because if you look at the Open Meetings Act and just the Open Meetings Act, it'll say 24 hours for a special meeting. But you are all lucky enough as a Board of Education to have a separate statute that relates to board meetings that says you as board members have to have 48 hours notice. So what that means would be that if someone called a special meeting and it was less than 48 hours notice, then it would be an emergency meeting. And then if one of you objected and said, I didn't get 48 hours notice, that meeting could not proceed. Okay. If you get 48 hours notice and you object, then it doesn't matter as long as the meeting was properly identified. Okay, so make sure that that's kind of clear. It sometimes gets confusing because you'll hear people say, well, the Open Meetings Act says you only need 24 hours notice. That's true, but we have a separate statute under Ohio law for Board of Education meetings that says you as a board, as individual members, have to have 48 hours notice. What does the notice have to look like? Well, for a regular Board of Education meeting, your notice is just that we're meeting, and the board's going to have its regular meeting, whether you have 1 a month or 2 a month. It's identified in the organizational minutes of that meeting, and that's all that needs to happen. Your agenda then can be whatever it needs to be in any given day when you have that meeting. If you have a special meeting, your notice of that meeting must obviously give the time and place of the meeting, but it also has to identify what the purpose of the meeting is. And there's been a lot of litigation in Ohio over what that means. And there's court cases that quite frankly run the gamut. And some courts have said, well, you just generally have to say what it's for. Others have said you have to be more specific. So what do I mean by that? Well, we had some litigation during COVID when some boards would notice special meetings and they would say, we're here to discuss the opening plan for the 21-22 school year. And then obviously they talked about things like vaccines and mask mandates and all those other things that we were dealing with when that was going on. And some boards took action when that happened. They might have said, okay, we're going to pass a resolution that either says we're going to mask or not mask, or mask in certain grade levels. And there was litigation on that because their notice of their special meeting didn't say they were going to take action. Well, I don't really necessarily believe that it has to say that you're going to take action, but if you think that there's a possibility, then it's always smart to go ahead and say, when Becky prepares a notice with Debbie or whoever else is board president at the time, to go ahead and say action may be taken to protect yourself. But the other thing about sometimes where we get in trouble with special meetings is, we have a special meeting lined up for a purpose, and then at the last minute, something else comes up that we need to work on. Well, that can't be added unless you have that 24 hours notice as it relates to the press. Okay, so that's when the 24 hours notice would be more important, because you already had notice of the 48 hours for the 48 hours for the meeting. Okay.
So if you change the agenda at all, you need to give 24-hour notice to the press?
For a special meeting,
Okay.
Debbie, but not for a regular meeting. Okay, so what else comes up in that capacity then, obviously, is, well, what is a meeting, right? Well, we know this is a meeting, so that, right, it's a public meeting, we've noticed it, but what about committees? That's where another round of litigation has arisen under the Open Records Act. So Obviously, if you as a board create a committee, let's say you have a finance committee, a student achievement committee, a facilities committee, anything like that, that is considered a meeting which is subject to the Open Meetings Act. Meaning therefore that you have to give notice that you're having the meetings. If you have regular meetings, you could do one notice for your regular meetings. Special meeting notices would also apply. The rules related to open meetings, meaning you have to keep minutes and go through that whole process would still also apply. Well, what if there's no board members on the committee? Is it still an open meeting? Well, the answer is yes, if it's a committee that's created by the board. So if the board creates the committee, it doesn't, under the law, it doesn't even matter if you're not present for it. Okay. Now this is where it gets a little dicey sometimes. And remember, you know, when the issues are clear, no one litigates them. It's only the issues that are a little muddy. Sometimes it end up in court. There have been judges in Ohio, and we haven't had a lot of appellate court cases or Supreme Court cases on this, but there have been judges at the common pleas level that have said, well, it's more than just who's on the meeting, who's on the committee, and it's more than just who created the committee. It's what is the purpose of the committee. So we had cases out there where a superintendent was asked to give the board a recommendation. So let's just hypothetically say you have a facilities project coming up and you as the board have asked the superintendent in public, Mr. Superintendent, Mrs. Superintendent, we'd like you to give us a recommendation on a facilities and plan. Superintendent says, well, I'm going to get some cover on this. I'm going to create a committee. On this committee, I'm going to have stakeholders in my community that are going to tell me, give me input. And eventually I'm going to have to distill that input and I'm going to have to give a recommendation to the board. There have been cases like that where the court has said if the purpose of the committee is directly to give input to the board on something that, or a recommendation to the board on something that they have to vote on, like a facilities plan, that even that could be considered an open meeting. Okay, so that's where things get a little fuzzy sometimes on this issue. Now it's not, if Michael or Becky or Lori says, I want to bring in my team to give me some input on something, that's not a committee. It's more like when you create this like official item, right? It has to be something more than just something de facto, meeting with your administrators and meeting board members, okay? But in that particular case, that district had created a facilities advisory committee and they had regular meetings, and the press wanted access to those meetings and the district wanted to keep it not transparent until they had a recommendation, and it ended up going to court. So, and there was reasons why it did that, but that's kind of an example sometimes where you can potentially get in trouble. What about executive sessions, right? Kind of going back to notice. I've been at your meetings before when you guys have gone into executive session, both present and on virtual, and you guys do it correctly, which is good. Just make sure that you always stay true to the way you have to do it, and that is that you have to be reasonably specific as to the purpose of why you're going in. It's not enough to say personnel, but it is enough to say to discuss the compensation of a person regarding a personnel matter, or to discuss discipline regarding a personnel matter. Okay, so you do have to be reasonably specific. You can't just cite all the reasons in the statute or just cite section 2 of item G. You have to be reasonably specific for the purpose of why you're going in. Know that and I know you know this as well, that executive session is a confidential activity, and that you're not permitted to share outside of the presence of anybody that's in executive session what's discussed in executive session at the time, if it's a valid reason for going in. And that's true. You can't tell your siblings, your spouse, your friend, anybody. The only people you're really permitted to talk about what happens in executive session is the people that were present in that executive session with you, and or legal counsel. If for some reason someone would have to contact legal counsel after an executive session and get advice. Another misnomer that sometimes comes up as it relates to legal counsel in executive session as well is that one of the purposes you can go into executive session is discuss pending or imminent litigation, but only if your attorney's present, right? So your attorney has to be present for that to happen, and that presence could be by telephone, it could be by Zoom, but your attorney has to be present for that valid purpose of going into executive session, if that's one of the reasons why you're doing it. Okay. Also, Another reason why you would want to keep it confidential if you have a conversation with legal counsel in executive session is that if one of you as a board member later disclosed what was talked about with legal counsel, then that would potentially be breaching the attorney-client privilege, and you'd be waiving that in the future for your other board members. So it's another kind of example of what happens with that. And then of course, you know that when you get out of executive session, you just declare yourself out. You don't vote. You don't vote because you're not permitted to vote in executive session. You can reach consensus though, right? So some people, you know, it's possible for you to give your opinion in executive session, give your viewpoint on something. You just can't actually have an official vote. So each one of you could say, this is what I think on this particular issue, which is vital and critical sometimes, whether it's collective bargaining, whether it's settling a lawsuit, whether it's determining if you're going to buy a piece of property or sell a piece of property. There has to be some ability for you to reach some consensus. Now, if you reach the consensus and it would take some kind of official action afterwards, then you would need to come out and do an official vote. Okay.
Bill, can I
Yeah,
ask you a question?
absolutely.
About open meeting? So can you define an open meeting?
An open meeting would be one that you are going to deliberate on public business, and it involves the potential action or taking some action regarding public business. Okay, so if three of you got together to watch a Ohio State football game that's on TV, technically it's not a board meeting because you're not deliberating or talking about public business. Although you know, you'd have to be careful to make sure you didn't do that, right? There have also been some cases, and they were mostly, when we saw them hit the courts, they went to the Supreme Court, but it was when outsourcing of busing was kind of a really hot issue in the late 90s. Since then, laws have changed and it's permitted, et cetera, but there were boards that were receiving the responses to an RFP. So let's say I was one of the transportation companies and I just came here and gave you a presentation, but you didn't deliberate on it. And then the next company came and did a presentation, you didn't have any discussion. The court said that wasn't a meeting because you didn't deliberate. You sat and received information. Again, I worry about those things a little bit, like why bother doing that? Like just go ahead and make it a public meeting. But at the time, it was a very contentious issue and there was a lot of protesting going on by the unions and so forth and so on. So I think those boards at the time were trying, if they didn't have to, not to have public meetings. But essentially, if it looks like a duck, sounds like a duck, it's a duck, it's a public meeting. Okay. So this next one kind of is a segue to open records a little bit, but there's also with the advent of email and text messaging and all the other electronic forms of communication we have and all the different apps, there's this potential problem with what I call the daisy chain meeting. Okay. So that's where I might be a board member and I call one of the other board members and then I say, okay, here's a piece of information. What do you think about this? And you tell me what you think. And then I get off the phone with you or I get off the email with you and then I email somebody else and I say, okay, what do you think? Well, this is what I think and this is what she thought. And by the time you get done, you've done this meeting that has transpired sometimes on telephone, but maybe mostly nowadays on email. And where that happens is, you know, maybe the board president sends out an email about something and then one of you hits reply all and then another one hits reply all. And then basically you've had this discussion or this deliberation that has happened through the course of email. And it has not, and it would otherwise be deliberation of a public issue. And we haven't been in a meeting yet. The courts have said that those are meetings. The seminal case on this is a case that actually, I got to defend, didn't win because it came to me after the fact, but we did end up resolving it. But there was a case in Hamilton County where there were 4 board members who wanted to sort of reprimand a 5th board member for some things that this board member had done. And there were some issues that came up related to a letter they had written. And the issue was, well, this letter was just presented at a meeting and all the other 4 board members worked on a letter together via email, made changes, made corrections and so forth and so on. And then the issue was, well, that happened in cyberspace and it should have been something that would happen at a regular meeting because it wasn't permitted to be done. So that can happen. What my biggest advice on that is sort of lose the reply all button as it relates to your district email. You know, first and foremost, always, if you can, utilize your district email for district business, which I think most of you are pretty vigilant about doing so. That there's reasons for that, obviously, as well. In case there's a records request for it, it's easy for us to be able to access that. But the other thing then too is that if you do get an email and you feel you need to respond, it's perfectly okay if, you know, Debbie talks to Paul about something and then Debbie talks to Mike about something. The only problem becomes if Debbie tells Mike and Paul, each of them think about that issue, right? You as the board president are sometimes going to need to talk to your other board members. So you're not precluded from doing so, you're just precluded from sharing that information, okay? We're also starting to see some cases where board members are texting each other during meetings. So we haven't had any cases that hit the court yet, but you know, sometimes we'll have boards that are split 3-2, and you know, the three will be texting each other, say this next or say that next, and the other one will be texting the other, you know, and because there's this sort of juxtaposition that's happening politically in a meeting. Remember, those text messages are public records in that case, if that's what you're talking about. So, you know, and just like in the issue that I talked about, the daisy chains, you know, not only are we potentially violating the Open Meetings Act, but we're creating a public record, which would prove that we have violated an Open Meetings Act issue. So be very careful about that. You know, and we've also had some situations where we could show where board members were texting people in attendance while meetings were going on. Again, that would potentially be a problem with the Open Meetings Act, because what you discuss at a public meeting should be in public. Okay. Any questions on that at all? Okay. I feel like, you know, sometimes I'm preaching to the choir, but it feels good sometimes to make sure that you're aware of it. Open records, I'm not going to spend a ton of time on that. Just that I think it's also important to understand what an open record is, to go back kind of your question about what an open meeting is. In order for something to be a public record, it first has to be a record. Not everything is a record, okay? Only things that document the organization's functions, policies, decisions, procedures, processes, and it's a long definition, okay? But essentially that's paraphrasing the definition. If it doesn't act to do that, it's not a record, okay? So if one of the two of you are talking to each other and it's not has anything to do with that, it's an email or a letter or a text, it has nothing, you know, did you see that baseball score last night, or did you watch the game last night? That's not a record. It doesn't document any of those things. It could be under district email, it could be under district phone. It doesn't matter. It's not a record. It can't be, if it's not a record, it can't be an open record. It can't be a public record. Not every record is a public record. So it could meet the definition of a record and still not be public. We have lots of items that are not public record. You know, medical information in our employees' files is not public record. Criminal background check information, social security numbers. There's a whole section of records as it relates to student records that aren't records. Okay, student records are exempt from being public records, although they are records. Okay, so that's the identity of knowing what you have related to that. Now, how does it relate mostly to you? I would, again, refrain from text messaging public business to each other regarding the board, because text messages are sometimes hard to maintain. Some people delete them all the time. Some people's accounts drop them after a week or 10 or 15 days. You don't know if the other side's kept them. So try to maintain, you know, if you really have to discuss something that you think would meet the definition of a record with someone on the board or someone in the administration, try to use email instead, because we can preserve that better. There are other exceptions that don't come up as much in the school business, but we do have a few other ones related to like law enforcement records and so forth, but they don't have a lot to do with you. And then the other thing about that I also want to talk about as it relates to open records is that we don't have a duty to like create documents. You know, sometimes the public will ask us for information and it's not a document that exists. And we might be able to create that document by extrapolating that information from other places, but we don't have an obligation to do that. We only have an obligation to provide an actual record. it might be smart for us to do that. It might be wise for us to do that. It might be a good practice sometimes to do that, but we're not required to do that. I always tell people, and mostly it's when I'm talking to treasurers, it's, you know, the Open Records Act does not give someone the right to make you take a quiz. It gives them the right to have documents when they ask for documents. Okay. So I think sometimes that is a little bit of a misconception that sometimes happens with the public. They're like, well, I have the right to know this. Well, the information you're asking for doesn't exist in the capacity you're asking for or in the form you're asking for. And whether or not we choose at that point to create that for them will have to be something that we have to choose, right? And then lastly, like, you know, what are there exceptions to us having to meet records requests? Well, records requests have to be reasonably specific. They can't be overly voluminous. They can't, you know, they have to be able to identify with some natural ability what they're asking for. You can't basically go on fishing expeditions. When you deny a public records request, you are required to provide a cite to either a statute or a case as to why you're denying it. And Becky's very well versed on that, and I've worked with her in the past on it, but just to be aware of that request. And then there's a reasonable period of time to comply with requests. And that reasonableness is going to be based on the nature of the request, the frequency of the request, how long it takes for us to do it. Does it require us to look at legal counsel review before we would respond, et cetera, et cetera. So reasonableness could be a day, it could be 10 days, it could be a month, depending on what has been asked for. All right, any questions on Sunshine Law? Okay. Levy do's and don'ts. I'm going to make this really easy. We can't spend district resources or funds to advocate for a passage of a levy. That should be as easy as it is, but it's never that easy. Advocating for the passage of a levy can look a lot of different ways, but we can't say we need your support. We can't say, you know, help New Albany kids. We can't say, you know, we can't. Our message to the public cannot look like we're asking them to vote yes. Now, that's what we can't do. But I always like to say there's a whole bunch we can do with public resources. You're allowed to provide information. You're allowed to provide statistics. You're allowed to say what you would do with the funds if you received them. You're allowed to talk about what would happen if the funds are not available for you. You can talk about what the consequences would be if the levy passes. You can talk about the consequences if the levy fails. You can talk about the district's financial position. You can talk about our staffing. If you were going to maybe say that you needed to build new buildings, you could talk about your class sizes being too high, or that your capacity for your classrooms or your science labs or whatever were at full capacity. You could talk about maybe you've had, you know, if it was an issue like that, maybe you've had issues related to fire safety because you've had too many students in particular places. All of that is permissible. And that all may be a great, wonderful argument for advocating for the passage of a levy, but as you see, I never once said, please vote yes. I say, this is why the levy's on the ballot. So a lot of times when and again, every one of these topics could be its own 2 or 3 hour kind of presentation, but when I'll go out a lot of times once like a levy's on the ballot, and I'll go talk to the levy committee and the administrators, and there'll be some board members that'll sometimes be there. And I always like to try to talk about what you can do, not what you can't do. And what you can do is you can use the district resources in a way to get your message out and to get your information out. You can't advocate for the passage. You can't ask for a yes. You can't say we need your support. You can't, anything that looks like that warm fuzzy feeling that we want you to vote yes, you can't do. Now you can say, remember to vote next week. You can say New Albany Schools has an issue on the ballot next week. Please don't forget to vote. Again, I didn't say anything about advocating for the passage of it. Those are all just informational type issues. This doesn't really impact board members as much, but it does sometimes impact administrators. So the problem with that issue sometimes comes up with administrators because administrators are sometimes asked to go present to different groups, maybe during a normal workday hour, 8 to 5, 8 to 6. And then the question becomes, well, if our superintendent went to the local Kiwanis club or the Key club or the, whatever the group is, and gave a presentation, and that presentation asked for support, is that violating the law? Would that person be using district resources to advocate for the passage of it? And I think the answer to that is no, because last time I checked, most of your administrators don't work a 40-hour work week. They work 60, 70 hours a week. So if they want to take an hour of their own time, even if it's during the workday, they're salaried employees. They're not required to be at work from X amount of time to Y amount of time every day. But if you're going to do that, and again, that's about doing what you can do, not what you can't do, it's important that when you get into that levy cycle, that your administrators who are being asked to do those things, keep a record, start keeping a time log of what they're doing on a day-by-day basis during that period of time. So if someone says, your treasurer was talking to this group and said, we need your support, you can say, well, that's perfectly fine, because that was their time, but wasn't our time when they were doing that. Okay. Again, you know, if a decision by a board to put a levy on the ballot, whether it be an operating levy or a PI levy or whatever kind of levy it is one that's not taken lightly. And when you make that decision to do it, usually it's something that you need and you want your public to support. It's just about whether or not you can use your public funds and your public dollars to do it. Now, one last thing on that, unless there's any questions, where people have gotten into some trouble lately is some districts have decided that they wanted to use their public funds to hire companies, consultants, to come in and help get their message out to the public, which is perfectly fine. I mean, you could hire a consultant to come in and do an annual report for the New Albany schools. Some districts do that. But where we found problems sometimes is that maybe a levy committee hires that same company. And then the lines between when that company's working for the board in a capacity which is perfectly permissible, appropriate, and when they're working for the levy committee, which is also appropriate as long as levy committee dollars are paying them, not public funds, can get blurred. So I'm not saying that you can't do it. I'm just saying that if you choose to do it, one, you should think about it, because there are some real benefits potentially of using the same consultant. But at the same time, you'd want to make it very clear that that consultant was tracking when they were working for you and when they were working for the other group, and that you did the same thing when you were interacting with them. So that does sometimes come up. Any questions on that? Okay, couple of interesting cases, and I won't spend a whole bunch of time on them, but most of these were over the summer, so some of you may have heard of them, but we haven't had much lately. But this whole issue about, and this is an interesting topic, maybe I can get some questions out of this, maybe I'll have to start asking them, but with social media, with all the interaction and activity that students have online, the old question has come up, and it's become even greater as, when does a student's First Amendment freedom end as it relates to their interaction with school, right? So the very first case we had was back in the 60s. It was Tinker versus Des Moines, Tinker versus Des Moines, and it was an issue that happened where students were wearing black bands to school to protest the Vietnam War. It was like in 1967, 68. That school district was a very conservative school district. They suspended and expelled students for doing it. And the issue became, well, did they have a First Amendment right to do that in school? Went all the way to the Supreme Court of the United States. Supreme Court, if you remember, the old line is, students don't shed all their constitutional rights when they cross the threshold into the school building. Probably prior to that case, the natural inclination was they did shed all of their First Amendment rights and all of their constitutional rights when they went into school. But 1960s were a time of change, and the court looked at this and said no. And so the court then said, you know what, they have First Amendment rights as students, but it's not an unlimited right. And they said, basically, if it's disruptive, if it's patently offensive, or if it's a violation of a code of conduct issue and it happens at school, then those First Amendment rights could be tailored. It could be, that was kind of the life we lived in for a long, long time. So we would basically, in schools, it usually became as something typically was disruptive, or unless it was patently offensive. So there were cases that came out of California where students are wearing gang colors or racial things or drug paraphernalia things. And they said, look, those are patently offensive. They're a violation of the pedagogical mission of the school, and therefore we can regulate that conduct. Well, what has happened in the last 10 or 15 years, and it's gotten worse, is that we have cases that are starting to happen where students are utilizing social media on their own computers, their own devices, they're at home, and they're bullying other students, they're doing other things at home that are not in school. And the question has become, what is your ability as a Board of Education to regulate that conduct? The Supreme Court finally heard a case on this last summer, or finally ruled on a case on it last summer called the Mahoning Case. And it was a situation where a girl had, I think she was a junior, and she had made varsity cheerleading as a sophomore. And then she tried out again as a junior and got cut. And then proceeded that evening with another student to basically take a Snapchat or Instagram, I don't know what it was, something like that, of her flipping off the camera and saying some derogatory comments about their cheerleading coach. And the school district kicked her off cheerleading. The interesting thing about this particular case is didn't even suspend her from school. And the case went all the way to the U.S. Supreme Court, and the U.S. Supreme Court said, no, that's the First Amendment right to engage in that activity because it wasn't disruptive to school. It wasn't disruptive to the cheerleading program in any way, and she had the right to do that. And so now, although the court ruled in favor of the student, the court still very much supported our ability as a school district to regulate speech activities if it's disruptive, if it's pedagogic, but in that particular case, they said it wasn't disruptive. So what I'm saying is that there is a lot more freedom for students now as it relates to their ability and what they put on social media and what they might put out there. And before we can sometimes engage in any kind of student discipline issues, we have to look very closely, is that this, is it protected speech? Does it meet any of these exceptions that might allow us to regulate it? And used to be a lot of times those things happen at school. And so you couldn't flip your teacher off at school. You couldn't cuss your teacher out at school because that was in itself disrespectful, offensive, and it happened at school. Well, now the situation happens. It's not happening at school. It's happening on their own devices, on their own time. And the courts have said, unless you can prove that it's disruptive at school, you can't regulate the conduct.
Is there some standard for what would be disruptive? Is there some test that could be applied to determine?
There's no bright line test. What I can say to you is that there's no bright line test, but there certainly are trends. And the trend seems to be if the content, and it really shouldn't be this way, but tends to be the way the courts have come down on this. If the content seems to be kind of a bullying or offensive or derogatory to other students, they have been more likely to allow us to regulate that conduct. If the target of the conduct, for lack of a better term, is a staff member, they've been less likely kind of to let us do that. And what I can give you an example of is there actually was, I have two of them. One I was involved with in federal court in Cincinnati, and it was so far back, it was when MySpace was still around. So, it's a pretty long time ago. But we had a student who had never received anything less than an A in his entire academic career. From first day he walked into school. His very last semester in high school, his teacher gave him an A- in some cute computer programming class or something. And him and his friend decided that they were going to create a MySpace account for their teacher, and they made up all these horrible allegations. I mean, I'm not even going to repeat what they were, but they were very, very bad. And of course, it didn't take long for the whole community to know that this had happened. The kids were looking at it and so forth and so on. It was very disruptive to that teacher because of some of the allegations that were made. And I got in front of the federal judge and she basically said, Bill, I'm going to rule against you because I don't see how it's disruptive at school. She said, yeah, your client, district was my client, but your client's teacher is upset about it, but nobody else is. So it wasn't disruptive. There was another case in Pennsylvania where something like that happened and they had to shut down a computer lab for 6 days because there was whatever was put out there was on these computers and somehow got in the hard drive of just that computer lab. And I thought that was disruptive to school. And the court said, yeah, but that's a really big school and you have 5 other labs. So no one was denied access to computers during that time. Now we've had other cases that were nowhere near that and courts have said that it is. So we don't really have, it's a totality of the circumstances issue, but the trend, and it's a great question, but the trend has been who has mostly been kind of the victim of those kind of issues.
So if it's 2 students one-on-one and one doesn't like what the other one says, that could be considered disruptive?
Potentially. Yeah, it might, maybe not if just one person didn't do it, but did it go around the whole school where kids, where there are lots of bullying, those kind of things happening.
Also, that is absurd.
Yeah.
Maybe this is too detail oriented, but did the school have a certain standard or code of conduct, or would that even matter in a case? Because I would think that if there's an expectation that's been placed on students. I mean, we have things that we talk about here every day that we have expectations of our students. They violate those expectations, there should be consequences. And if there aren't consequences, whether it's in school or outside of school, then why are we doing it?
Well, there could be, it's a good point. There could be outside consequences, both and criminal statutes for doing those things, like, telephone harassment, electronic communication harassment, those kind of things could exist outside of school. So it could potentially be a criminal nature outside of school. The question really comes down to, does it violate the student code of conduct in a way that is not protected under the First Amendment rights? And it's going to be a totality of the circumstances on any particular given case. So it's kind of hard to talk about it and outside of knowing a particular case. The issue regarding this Mahoning case that the Supreme Court looked at, they looked at a couple of things. One, that the cheerleader advisor wasn't a faculty member. The thing was only up for a short period of time because it was like a Snapchat and like disappeared, and looked at all these different factors. But they basically said outside of that little issue of that group, it had no effect on the school. It's also one of those issues that it very well could depend on what court it goes to and who the judge is, right? But there's no real bright line test. And we were hoping that when this Mahoning case, and it's an interesting case, if you get a chance to read it, you can look it up. It's called Mahoning. It was last summer, June, and when you get done reading the case, it's kind of like a head scratcher. You're like, well, what did the court really just say? Okay, the court said you can't discipline her, but you still have these rights to do it in certain situations, but we're not going to give you a bright line test. It's like a lot of constitutional law issues. It's going to be a totality of the facts.
So Bill, to that end, and really where John's going from a consequential standpoint, because I've read the Mahoning case, and I will tell you that it was, in my opinion, disruptive because it took hours of time from personnel in the school district to basically facilitate phone calls and emails and conversations with parents and cheerleading advisors and cheerleaders and the administration. And the reality of what that means, that is disruption. So I respectfully disagree. I understand the court has the right, but when you read the case, it was disruptive at school. And I get it was a finite period of time and it was on social media and everything that came with it, but that's part of the challenge. And that's where I would go back to, and we just talked about this at the previous Board of Education meetings, and it's on that wall over there. But if you would just start with kindness, dignity, and respect, and the environment of expectations that Mr. McClellan's talking about, there should be some understanding that that just isn't what we're supposed to do at school, and how we basically interact in this world to basically support academic and developmental needs. So I respectfully understand the legal side of it. I've read the case,
Yeah.
But personally, on behalf of those people sitting over there too, called building administrators, we understand the disruption it causes, because when it happens outside of school, it all comes right back into school. And we spend hours dealing with some of this stuff. that has nothing to do with what our fundamental purpose started as, but we spend hours dealing with it because it is the aftermath.
No, two responses to that too is like, I don't know how well, like whenever you read a case, you don't get you only get the facts and the court decides they want to share it with you, right? I also don't know how well it was advocated by whoever was advocating it for the school district, right? And then the other thing is, you know, I'm not so sure that they're like, I think if the same situation would happen here, I think you have a student code of conduct that relates to participation in extracurricular activities. I would use that. And I would say it's a privilege to be a cheerleader. And therefore you've violated that privilege. I don't know if the court doesn't talk about that at all. And I don't know if that just wasn't brought up to them.
I don't know.
Because the whole time I'm reading the case, that's what I'm thinking. Why? I mean, we should be, if you sign a pledge that says, I won't do these things if I want to participate in extracurricular activities. It's not a right to do that. But I agree with you. I mean, and again, I would also tell you too, like, it doesn't mean that we still won't act to do something. It just means that we have to take those things into consideration and be very calculated and determine when we make those decisions that these things are out there that we have to deal with.
So we can still have a code of conduct. We can still hold people accountable for their behavior.
Mhm.
We can still do much, if not all, of what we're currently doing. However, to the extent that there are adverse consequences to the speaker in this case, we have to be aware that there may be a difference in the extent of what we can do if it's student to student or if it's student to faculty to adult, right? Is that what you're saying?
Yeah, I mean, it would have, here's what I can tell you. Like, there were cases prior to this that were in Ohio, never got to the US Supreme Court, where it was long before social media and emails or any of those kind of things. So the one I can remember is kid saw his teacher in a grocery store and cussed her out. I don't even remember reading that. Was the case that we all read a long time ago.
It's old.
Yeah, and it happened in some little farm community in Ohio, somewhere up north. And the court said, absolutely, you can suspend that kid for that, for all the reasons you're talking about, right? And First Amendment issues were brought up, right? Now, it didn't get to the US Supreme Court, and it didn't probably get the ACLU or somebody else behind it to push it, to get it there. And I will tell you that if you look at the line of cases that deal with these issues, the circuits that tend to be more conservative and the circuits that tend to be more less liberal will usually identify that it's permissible for a board of education to regulate that conduct. And then you'll look at some circuits that are more liberal in their application of things, and they'll say that it's not. I don't want you to take this walking away here that a student can just write or do anything they want to do on social media and that it's out of our hands, because it's not.
Yeah, I will tell you it's not.
It's not. By any means. It just means that it's another thing that we have to look at as it relates to that conduct. And you know, the court waited a long, long time to address this case. And I'm not even going to tell you that I'm going to try to guess how the US Supreme Court works. But there were all kinds of better cases that had been presented to them over the years on cases like this that they refused to take. And they took this one for some reason, which I thought, you know, I guess I would say it to any of the justices that were there if I could talk with them about it. I think it was a poor case to take because it doesn't draw a good line. There were other cases that they could have drawn a very good line on.
Bill, does it help that our expectations are really clearly laid out for students?
All those things would help, right? Like, you know, if you have a culture in your district or a character situation, or, you know, you have things that you're building as a part of your curriculum and your culture as an organization, those are all things that I think you would argue very strongly about. Yeah.
Michael just pointed to our new
Yeah.
banner.
Yeah, right.
And
Absolutely.
we have been having a lot of conversations about our values and expectations of our school community.
I mean, if I was advocating for you in a case like that, that would be something that would definitely enter the argument, right? And you know, if you read the case, Michael, you have to scratch your head when you're done reading it.
And I would agree, the athletic code of conduct should have been presented.
It should have been
baffles people when we talked about it from an administrative perspective as to why that was not one of the arguments.
Yeah, yeah, and remember, like, you know, when that happens too, like, it could be that we might say, well, you know, I don't know if we have the ability to suspend that student from school based on what they've done, but if they participate in extracurricular activities, and we might have the ability to do that. And I think you have a large percentage of your students that do that here at New Albany. And if they were like me when I was in high school, that was way more important to me than what I did at school at the time. You know, take me off the football team or the wrestling team, and we got a problem. You know, the other things when you're that age don't seem as important to you. So I think there's more ways to deal with it, right? But by no means is it carte blanche, you know, do whatever you want in that respect. I still think you have the ability to regulate that conduct. But it's an interesting case, and I recommend that if you, I don't know if you need something to go to bed at night when you read, look it up online and read it, because it's an interesting case. It really is, and it goes into the. I don't want to take too much of your time, but I'll just give you an example. When in the 1980s, we didn't know if students, before we suspended or expelled them, really were entitled to due process or not. And when we did that, we also didn't know what the standard was for searches of students in school. Some people thought it was probable cause, like a police officer needs. Some people said, we'll search you whenever we want because you're in loco parentis. It's like me looking at my son's sock drawer. I didn't need any kind of standard to look in the sock drawer. He lived in my house, right? So the issue was, where's this standard? And without going into detail, like they picked a case out of New Jersey called TLO, and it was a great case to pick because it just drew the line, right? And it was a perfect set of facts, perfect set of cases to say, you know what? Standard's not either one of those. It's in the middle. It's reasonable suspicion, right? This was a bad case, in my opinion, that the court picked to try to make a statement on this. So,
you mentioned in loco parentis. Is there case law, or are there standards that relate to that principle as far as our obligation?
Yeah, there is, and although I think it's developed over time. You know, probably in the 50s and early 60s, it was just that. It was in loco parentis. I mean, there was no standard for searches. There was no standard for First Amendment in school or any of those things. I think that it still exists, and that when we have those students, there are students who are responsible for the care, custody, and control of them. And unless in some way that care, custody, and control is being modulated or modified by constitutional law or something, then that still exists. So a good example sometimes happens when, you know, and I'm sure your principals can tell you this, the police will show up sometimes and say, we want to talk to Billy Dieters. You do? Why? Well, you know, he was a person of interest in something that happened uptown last weekend. Well, we're in loco parentis of that kid. We shouldn't let the police have access to that student without notifying their parents. Now that loco parentis might be a little bit modified in that, why do you want to talk to Billy? Well, you want to talk to Billy because there was an allegation that he's being abused by his father. Okay, maybe at that point, then we're going to let the police talk to him, but we're going to have an administrator present. So it's a loco parentis, but there are some sort of nebulous aspects of that on the fringes of that. But at the end of the day, I mean, when we have those kids, they're our kids. We're responsible for them. But that's a good example of it. Right? Okay. There were some kind of interesting issues regarding educator misconduct that came out. Laura, you may remember some of this, but sort of at the end of last summer, there was a few bills that came out regarding the fact that when you are going through the hiring process to hire a teacher now, you are permitted to make an inquiry to the Ohio Office of Professional Conduct to see if there are any complaints out regarding any of the prospective people you're employing, which in the past they wouldn't do that. So that's another kind of a good development that has occurred to the process. Of course, Juneteenth has come up a lot lately. We know Governor DeWine signed a statute that said that Juneteenth has become a state holiday and they have modified the school statute for boards of education. There's a little bit of a nuance with that though, and that if you have a collective bargaining agreement that identifies and has a holiday provision and you provide holidays in there that are different than what the law is, then you could certainly say that our collective bargaining agreement supersedes the law because we're not following the law as it relates to that. So is there an obligation to provide Juneteenth or not? Most districts are just going ahead and sidestepping that because they have a great amount of people who are also classified individuals who are not part of a collective bargaining group, and you've got to give that to them. And typically we try to treat those groups the same. But there are some arguments you can make, like for instance, with your OPSI group, if you wanted to argue, we're not going to provide Juneteenth because we give the day after Thanksgiving, and that's not a holiday. So if you want to trade one for the other, we can do a trade, but otherwise we already are doing things that are contrary to the law. I don't know where you guys have decided on that issue, but
We haven't done it yet.
it's something you got to talk about, right? I get a lot of questions on that too. Okay, probably last thing I want to talk about is just some Title IX issues, and Title IX has had a lot of play probably in the last 2 years, 24 months. And so first of all, Title IX is an anti-gender discrimination statute under Civil Rights Act. Title IX relates to schools and gender. First really started to come about and become popular mostly at the university level, because there were suits that were filed that said universities are spending more money on male athletics than they are on female athletics. Therefore, a disparate treatment has occurred and there's discrimination. And that's why, obviously, the biggest problem has always been for universities. There's 110 scholarships on the football team. There's no corresponding sport for female or women's athletics that has 110 kids on the team. So that became a problem. And so what you typically saw was a lot of universities were dropping certain male sports to try to get those numbers in balance. There could be things like, where more money was spent on facilities for the male locker rooms and the women locker rooms, et cetera, et cetera. That's where we first saw Title IX, right? That's kind of where it first developed in our lifetime. Then that started to creep down into, that same concept started to creep down into high schools. So the Office of Civil Rights on the Department of Education, which is a federal office, their office here is in Cleveland, Ohio. That's where you have to file complaints regarding the Civil Rights Act as it relates to schools. And so then we started to see school districts receive complaints, and it was kind of the same kind of thing. So, like the girls softball field is a disaster. Look at the Taj Mahal for the boys team, and locker rooms, those kind of things began. We even saw cases that would arise where people were filing complaints because the women's basketball team played on Thursday nights and the boys played on Friday nights. And so the women wanted primetime weekends, and you name the gamut. That's where a lot of those cases were. Then Title IX became a big issue, mostly related to the Duke lacrosse situation, where the lacrosse players were accused of engaging in a sexual assault at Duke University. There was a Title IX sexual harassment complaint filed. And if you recall that, I think quite a few members of the Duke lacrosse team were kicked out of school. There was even a criminal prosecution that I think didn't get past the grand jury, or got past the grand jury and then got dropped quickly thereafter. And then there were lawsuits that were filed by the players, and then eventually the woman who had made the complaint recanted her story, I think, if I recall correctly. And so then the issue became, all these Title IX regulations came down, and Lori knows them very well because she's your Title IX compliance officer. She does a great job dealing with it. But all these additional regulations came down, mostly as they relate to how we have to investigate a Title IX complaint. It used to be that you just did a reasonable investigation. Now there's some very specific things that you have to do. Quite frankly, nothing that we weren't doing before, but now it's just made it much more codified in that process. And that has, those actually came down in regulations. And so those are in play right now. And of course, they gave those to us right in the middle of COVID, if you remember that, and gave us no ability to delay implementing them. Well, I think the latest place where Title IX is really starting to rise up is as it relates to transgender students in public schools in our country. And the biggest problem that we're having with this as a society, not New Albany schools in general, but just as a country, is that there is not great guidance, and there's really no specific law that you can potentially cite to And what I mean by that is the Obama administration had came out with a joint letter between the Department of Justice and Department of Education and identified all these particular things about transgender students in schools that have to happen. But it was a guidance letter. It wasn't made under the rulemaking authority under Title IX. So if you're, I don't want to do my little how the bill becomes a law. Remember that on Schoolhouse Rock? but there's another. There's three types of laws that we have in this country. There's statutes, there's case precedent, and there's rules. And rules are developed and based on statutes. So a legislature will pass a rule. They'll say, you know, we want clean water in our country. And then they'll say, we're going to create this thing called the Environmental Protection Agency, and they're going to develop rules because we're not going to get into the parts per million of whatever can be in the water. We don't know any better. We just know we want clean, clean, healthy, safe water. And so then you have regulations that get put in place, and there's a process that regulations have to go through. They have to go through a comment and rulemaking, and they got to go through this whole process to become. And then they have the effective law. They can be challenged. But they have like this deference that the courts have to give to them because they're identified as the experts, and they're supposed to be writing a rule which is consistent with the purpose of Congress or the purpose of the legislature in drafting it. Okay. Irs regulations are mountains of those, right? Well, the thing that the Obama administration had done at the time was didn't go through that process. And there were a lot of people that, you know, this is a hot button issue. There's people on all sides of this issue. And so one side says, well, look, here are the rules. One side says, no, those really aren't rules. Okay, but the OCR is gonna enforce them because the OCR, Office of Civil Rights, at that moment in time, works for this administration who's saying you will enforce these. Then we have a change in the administration. The next president comes in and says, nope, we're not enforcing any of those. We're not going to enforce Title IX in schools in any capacity related to transgender unless it's bullying, and then we'll enforce it. So then that happens, right? Well, then Biden's administration comes in, and they're saying now that they want to go back to where the Obama administration was related to that, and they're in the process of rulemaking. But they've also told the Office of Civil Rights that we are going to enforce Title IX as it relates in transgender in schools as it relates to, you know, sexual identity choice for bathrooms, locker rooms, those kind of things in sports. So that's where we find ourselves in this place right now. And it's difficult to give advice on it because if you want to be on either end of the spectrum right now, you can grab a hold of something and use it to argue with, right? One side can say it's not a rule, one side is saying this. I try at this moment to like just kind of like push back from the table a little bit as it relates to all these rules and regulations and say, what do we do for kids in schools every single day, right? Because we've had issues like this in schools, whether it be transgender, whether it be kids that are anxious, whether we have kids that, you know, lost a puppy or lost their father or lost their, you know, mom and dad got divorced, and we have all kinds of issues that happen that we have to deal with kids on a daily basis in schools, and administrators and teachers and everybody, they make accommodations so kids can be in healthy, safety environments to learn in. I believe that we're probably going to get rules. I think those rules are probably going to come down this summer, and they're probably going to come down more in line with the Obama's administration's take on this than what the Trump administration's take on it was. But I think on a daily basis, like, you know, we are, I don't know, I'm always afraid to say this because I think sometimes it can be taken wrong, and I want to make sure it's very clear about this. I think a good process to deal with transgender issues in schools is very similar to how we deal with accommodations for kids under 504 issues. Now, when I say that, I always get worried because I don't want someone to walk away and think Bill Dieters thinks transgenderism is a disability. I am not saying that. I'm just saying that we follow kind of a 504 process all the time for kids in schools. We find out what are the issues that a student is dealing with in school. How can we better accommodate their learning environment to deal with those issues? And so our advice from our office for probably the last 8 to 10 years has been to kind of handle it that way. I think I've sent this to you before, but it's kind of like a transgender intake process form, a kind of a guideline that if you have a student that comes to you and says, I'm transgender, I need accommodations, whether it's a bathroom issue, whatever it may be, you sit down with the parents, hopefully, and with the student, you address what the concerns are, you give your concerns, they give their concerns, and you come up with a plan that's workable for everybody. And 99 out of 100 times, in my experience, that has been extremely helpful. And when I say a plan, like, you're getting a lot of information. You're going to find out, you know, if you've spent any time educating yourself on transgender issues, you know that it typically is not something where it happens overnight, right? There's sort of a transition from identifying from one sex to another, and it can take time over time. And so you find out, where's that student along in that process? You know, have there been psychologists or other mental health professionals involved? If we had hormone treatment therapies, you kind of try to get an idea of where a student is in that continuum, and you work to find a place that works for everybody. And I would say typically that has been the best approach. I think forget what our exact name of that form is, but it's a form, and it's just a list of saying, just like you would under a 504 meeting, you have a list of questions that you try to answer and issues that you go over with the parents and come up with a place for them to be. And I believe you've been doing that for the last few years. And most of my clients that have taken that approach have, I think, been successful with it because we make accommodations for kids all the time. You know, what tends to sometimes happen when I talk about this is the question I get is, well, what about the other students aren't okay with that plan? I don't know if I have the best answer in the world for that, other than it seems more to me, and maybe this will be somewhat controversial to say, but I'll just say it, that we as adults tend to have more of a problem with it than the kids do in school. And when I say that, it's I don't know, I've you know, it's rare that I seem to find that it's not us as adults that are having the issues related to it, and the students find ways to adapt because they do it all the time with all kinds of issues in school to accommodate. So I don't necessarily, I don't believe that it requires you to change policies. I don't believe it requires you to write specifically in your policy at this time anything about transgender, because you already have the fact that you won't discriminate based on sex in Title IX, and that's included. I don't necessarily think it requires you to create anything other than what you're doing, which is looking at it at each individual kid and student on the basis of what that student needs and how can we make reasonable accommodations for that student in school. The best advice that I can give anyone related to that at the moment, I do think we'll have regulations, and they'll probably be out at the end of the summer, unless they're delayed because of everything else that's going on in the world. But and I think at that point it'll become a little clearer for us as to what the rules are. I don't think it'll change what you're doing, because I think you're already probably following those things to begin with. But I think we'll have more of a rule to look at. I don't know if there's any questions on that. Typically there is, I don't know.
So you can look over here and see our value statement that says, you know, we're committed to fostering an environment of kindness, dignity, and respect. So I think that's consistent with the 504 process that you're speaking about, and the way we've been handling these issues, you know, for several years. I do want to make sure I'm completely clear, and that whoever's watching is completely clear. The guidance that we have today. So you said Title IX, you started by saying Title IX is about gender. When I look up Title IX, it says it's about sex. Has that been clarified in any of the three processes? Either has Title IX been formally amended in legislation? Has formal rulemaking been done to modify the statute so that it is related to gender, or, you know, has there been case law that has modified it accordingly? But just want to make sure.
I believe the answer is to all of the above, yes. But let me tell you how they get there. Okay. So sex also is the only, like gender is not like this whole sexual, when you look at sexual harassment issues, some people look at sexual harassment under the law, the civil rights law, as being some like quid pro quo type sexual harassment, right? But the courts have gone further and says anything regarding sex, including gender, can be sexual harassment. So if you are, even if you are treating somebody unfairly because of their sex, gender, that can also be considered hostile work environment above and beyond just gender discrimination.
Okay, before you move on to the other two, what you're saying is there is case law that establishes that Title IX applies not just to sex, but to gender as well.
I believe so, but I would need to look at that, Phil.
Okay.
But I'm pretty certain there
Then
is.
we have the other two. The legislative, the law has been amended
No,
legislatively, so that hasn't happened.
no, but OCR does say, which is the Office of Civil Rights, says that they consider Title IX to affect transgender issues.
Okay.
And it says sex in Title IX. And the way they get there is by to look at the case law as it relates to sexual harassment cases and say, well, that's the same thing that we're doing.
I mean, we still want to do what's right for kids. We still want to treat everybody in the district with kindness, dignity, and respect. We still want to do all those things.
But I think what you're hitting on is the problem, is that because of things like that are out there, anybody that wants to grab on anything, like someone wants to be completely against transgender issues in school, they can grab those things and hold on to them and, okay, well, they have some legal merit. And then the other side can grab things and hold on to that has legal merit. And then we find ourselves kind of in this middle place of trying to figure out what the best thing to do is, and we don't have a direct law that says this is what we should do. But I think we're already doing what you said, creating environments for kids to learn in and making accommodations. And those, like, when I say we make reasonable accommodations, right? Like when we make a reasonable accommodation, that we take into consideration how that impacts the total learning environment, right? If we have a student who needs certain accommodations, we have to think about, okay, well, can we make that accommodation? Can it be reasonable? And how is it going to impact the learning environment as a whole, right? We have to take the individual and the whole together in that process. And I think that's what we do.
Sure. And I think you also said 99% of the time, the process works.
It does.
Right? The question becomes that 1%, the person, the student that we're trying to work with, the family we're trying to work with is not satisfied with the outcome, or someone else
That happen on the other side.
is not satisfied with the outcome.
And those become the more difficult cases to deal with.
Right. So that's where we're trying to understand,
Right.
what we're obligated to do, what the right thing is to do, so we can do the right thing.
Well, I can tell you right now that given what, literally the 4 years that the Trump administration was in, the Office of Civil Rights went silent. Didn't hear anything. When the new administration took over, they became very active again. And they have clearly said, maybe not officially, but unofficially, that we are going to investigate transgender cases if we believe there's complaints and that you are not making reasonable accommodations for these students. Now, if somebody wanted to fight them on that, would they get all the way to the point where they could take federal funding away? I don't know. Typically, we don't find that out because we end up resolving those with reasonable solutions and settlements for everybody. And then when I say settlement, I don't mean paying money. I mean figuring out whatever the problem is and fixing it, right? Yeah.
We're going to do the right thing for kids.
Yeah. But it's challenging from my perspective of having to give advice on it because I can't point to something and say you have to do this, right? Let's see. I have one other thing that might be worthwhile to talk about too. I think the hardest thing to find right now in the world is a bus driver. So I don't know how are you guys going, Michael? Are you okay?
No.
Yeah. I mean, even the transportation companies like this, the First Students of the world and the Petermans of the world can't get bus drivers. I know at one point there was a large school district in Butler County that had 11 routes that were going unfilled every single day. And so their parents are upset about that. I understand. And so there have been complaints that have been filed recently at ODE. And ODE had come down, I think it was up here, right? Was it Columbus Grove?
Columbus Grove.
They fined them a pretty hefty amount of money. And then I think they're in the process of fighting that and appealing it. That's a kind of a, if you want to talk about a hot button issue right now, it's a little bit of a hot button issue as to if we don't have the bus drivers, what do we do to get kids to and from school? So some issues have come up like regarding like payment in lieu of transportation issues and things like that. So.
I have one more question on the previous topic, sorry.
Sure.
We covered, you understand where we are with regard to bathrooms, locker rooms, et cetera, and the general process. We didn't talk about sports generally.
Oh, yeah. Well,
Is there clear guidance there? I know it's been all over the news, so I just want to make sure again, that parents are clear.
well, the case that's been on the news, obviously, right, is the male transition to female that I think swam for Penn, right, in the issue, right? So Ohio High School Athletic Association does have a policy on it, and you can go to their website and look at it if you want. But effectively, it allows a female transitioning to a male to participate in male sports. In essence, if a male is transitioning to female, identifying as female, they're not permitted to participate in Ohio High School Athletic sanctioned interscholastic competition unless they can prove a certain amount of therapies and hormone issues and things like that they've gone through from a medical process. Now that's their official stance. It hasn't been challenged to the best of my knowledge. If it is challenged, it's always, the Ohio High School Athletic Association is always an interesting animal as it relates to Ohio. Okay. I've had a lot of cases in my days with them, mostly on the same side of them, but are they a government actor or not? Are they government or not government? They used to pride themselves on the fact that they didn't take any school funding, that all their money was gate receipts. And that's how they would say, we're not a governmental actor because we take no tax dollars. There were high school athletic associations. Tennessee has a really large one, and they've been embroiled in a lot of cases over the years, and they've gotten to the federal courts and so forth. And I think Ohio High School Athletic Association looked at those states and said, that's why we're not taking money. But I just saw I think they did take money this year because they had to. Because of COVID, because their gate receipts were down, they were going to go under. So I don't know what'll happen if it's challenged, because I don't necessarily think that the Office of Civil Rights would say that allowing someone who's identifying as female from male can participate, but that male from female cannot, because that's directly in contrary to what's happening in the Ivy League at Penn. So, but it hasn't been challenged. And if it is challenged, we're going to be, whatever school gets challenged is going to be in a big predicament. Because if you get challenged, then you could potentially be looking at dealing with Office of Civil Rights complaints and potentially lawsuits. And if the Ohio High School Athletic Association still says, but that's our rule, and if that person participates, you'll forfeit any of your games. That's where that 1% you're talking about, that's where it could get dicey.
The current rule under Ohio High School Athletic Association is as you described.
Yes.
Okay.
So it says a transgender, because I didn't talk about it, I printed it out and I forgot to talk about it, but a transgender female, male to female, student athlete may participate after taking medically prescribed hormone treatment related to gender transition. So before they can, a transgender female can compete in a girls' sport on a girls' team, they must either have a minimum of 1 year of hormone treatment or demonstrate to the commissioner's office by way of sound medical evidence that the transgender female athlete does not possess physical bone structure, muscle mass, testosterone, hormonal, etc., or physiological advantages over genetic females of the same age group. Now that sounds to me problematic, given OCR's interpretation of this, but that's the current rule. That same doesn't exist for someone that's identifying as male. But it's yeah, I mean.
And then last question for
Clear
me.
as mud.
Last question for me. I mean, it's clear as mud. Exactly. But, understanding that there is guidance, there is, there are rules that exist, whether they're challenged or not. We we need to operate on the basis of what is.
As a current,
Um,
if you call me today, I'm gonna tell you to follow that advice.
As it relates to privacy rights, because this has come up as well.
Mhm.
Student tells teacher that, they feel that, that they're transgender and is uncomfortable telling their parents. Is there an obligation on the part of the school, one way or the other on that question?
I was trying to avoid that question, Mr. Darrow.
I wasn't trying to set you up. I'm trying to make sure that, that we've got clarity here.
So how best to answer this question? I think it's really, really complicated, first of all. If you as a teacher or an administrator believe that by telling the parents you're going to put that kid in danger, then obviously the answer is no, we're not telling the parents. If the student says, well, I just don't want them to know, I think the appropriate way is to deal with them with the kindness, dignity, and respect, and have them be able to talk to some guidance counselors and some people to talk about why it's important that your parents know these things, even if they obviously you think they're going to be objective to it. And perhaps through some guidance of that student, convince them that it might be in their best interest for them to tell their parents and not us. At the end of the day, and this, I've gotten to some pretty heated arguments with guidance counselors over this and some teachers. I think at the end of the day, you remember my job is to protect the Board of Education from liability. At the end, that's where I have to go. At the very end of all of it, that's where I have to fall. And I do think that we are in somewhat of a loco parentis of that student. And so we may have to get to a point that if we don't necessarily believe the student's safety is in danger, that we may have to get to a point where we have to tell the parent that. I don't think we jump straight into it. No, we're telling your parent. Because I think it's a process, but I do think that we should encourage the student as to why their parents should know. What I don't think you want to have happen, and I've seen this happen, it's sad, but I've seen it happen. Billy wants to be called Wilma. Billy's transitioning to a female. Everybody at school has accepted it. Teachers have accepted it. Kids have accepted it. Mom and dad don't know about it. Mom and dad come in for a parent-teacher conference. Teacher uses the female pronoun. Excuse me? Well, yeah, she. Parents find out. Wasn't a good situation, right? So I think you want to avoid that, obviously. It's a tough situation. I mean, I don't know. I don't know if legally there's an answer. We have to, if we're obligated or not. I try to think of myself if I was a parent in that situation, like what would I want to know that? I would want to know that. It would be important to me because I want to support my child. I don't know if it should be for us to choose to make that judgment call for the parent. But at the same time, we're also trying to protect the interests of those kids and their emotional well-being. So it's a balance, precarious balance. So again, 99 out of 100 times when that's come up, there have been really good teachers and administrators and guidance counselors that have that kid's best interest at heart, have found a way to resolve that where the student tells the parent. Not all the time, and then you got to deal with that 1% case.
I think your description makes really good sense, and I think it's very consistent with how we would handle things. You have conversations with people, you treat people with kindness, dignity, and respect along the way. And if we have believed that a student is at risk in some way, we have mandatory reporting requirements under those circumstances anyway, right?
Right. If we had a situation where we felt that if the parents had knowledge of the student's safety would be at risk, then if that was told to me, my first advice, and I know these administrators already know this, we'd be calling children's services right away to say you be aware of the situation.
Okay.
Anything else in general? I know I probably took way more time than I was supposed to.
Bill, thank you.
Okay, sorry.
You
I get
know,
started and I can't stop. I feel like I'm a law school professor. So
it's really good for us to understand the law and it's important for us to understand it. I think, we do go back to our statement of purpose and our values statement in all of our actions and how we make decisions. And it sounds like, we've always been in the right lane with how we have looked at individual situations and making sure every student can achieve the best academic and developmental outcomes, as well as feels like they're treated with kindness, dignity, and respect. And I think those are the things that will continue to guide our decision-making.
Yeah, and like I said, I think that we'll have rules which will make it a little bit easier for us to navigate those waters in the future. But I don't really think that if the rules came down tomorrow, it's going to change one thing that you're doing here in New Albany with your kids, because I think you're already following them. It might require us to maybe dot some I's and cross some T's, but in essence, for all intents and purposes, we'd be doing exactly what we're doing now. Right. And then just finally, thank you for having me out. Usually I only get to talk to you when there's like some crisis or in the middle of some horrible thing. So it's nice to talk to you just in a way where we can just converse. So
Thanks so
Thank
much,
you.
Bill.
okay, guys, take care. Have a nice rest of your
Phil already said, but I appreciate the discussion of the open records and other discipline issues and Title IX, because I think it also sheds light with what you said about the uncertainty and the lack of answers. Really, sometimes there is no black and white answer in many cases. And
Well, I mean, you do tax work sometimes, right? A little bit. Yeah, well, there's a lot of unknown things in your world, right? And you're trying to navigate like what the best advice you can give. And I just always, there are some areas that we just don't have right line tests. I mean, so it's tough.
And we're coming out of a cycle where there was a lot of uncertainty as well at the federal, state, and local level as to how we handle things. So I think just the discussion here, and I know we don't have much of an attendance, but we do have online presence and the ability for.
And it just seems like.
Listen in to what you said, and I think it really sheds some light on the issues of the day as well that are in the press every day.
And issues like this have become more and more amplified because I think our society is just so polarized on a lot of these issues right now that it's sometimes kind of hard to get people to think about, well, there is a middle ground here, which is okay for both sides, and it's tough sometimes. I mean, it's because people are passionate about issues like that. So, right.
Thank you, Bill.
Okay. Thank you all.
Have a
Good
good
evening. Maybe spring will come at some point. See you later.
Have a good night. All right, our next discussion item is our permanent improvement plan, the How Part 2. Ms. Jenkins.
Thank you. I will just ask Superintendent Sawyers to jump in if he feels like he needs to add anything to this. So we're revisiting the permanent improvement discussion that we had. I think March was the last time we had it.
February.
Maybe February. It was February. It's been a while. So we're going to remind you of some things and then prompt you to maybe discuss a little bit what we want to do going forward. As always, as you said earlier, President Kalinowski, our purpose is what drives us in all of our decisions. And so you'll see this in this presentation. You also see it in my 5-year forecast presentation. So I want to remind you that our current permanent improvement levy expires December 31st of this year. So we need to make a decision whether we let it expire, do we renew it, do we replace it? As a reminder, when we presented the permanent improvement plan in January of 2022, we showed you the need. We had a lot of detailed information, and that ultimately it's a $2.5 million over a 10-year period. Each year is an average of $2.5 million in need. So how do we fund it? So that's why we started our how in February. Remind you that we do have 0.75 mils of bond debt rolling off at the end of December in this year. And that costs a homeowner of $100,000 house, $26.25. Why do we do it in $100,000 increments? Because it's easy to do that. And then you just multiply by the hundreds of thousands of dollars. We understand that we do not have $100,000 homes in New Albany. A question that was asked at the last meeting was, what was the cost of the 0.93 bond levy millage that's rolling off in 2026? And right now that is $32.55. And I think the comment was Vice President Newmoff And it was, would that also then help when we talk about what if we would go with the option, the 2.0 replacement levy, which would actually have a slight cost to homeowners, what would those last couple of years of the 5-year levy save, or how kind of offset would you have if that 0.93 mil levy goes, or bond issue is gone? Sorry. Then to refresh your memory, a 1.5 mil replacement levy would generate $1.75 million. 1.75 mil replacement levy is just over $2 million. And then the 2.0 mil levy would be $2.3 million. Going back to and reminding us again, we need 2.5 million annually based on the permanent improvement plan that we presented. So you're increasing the amount of money going into the permanent improvement fund by either 500,000, 800, or just over $1 million. We're transferring $1.3 million now from general fund into the permanent improvement. Because if we remember, when we passed the 1.25 mil levy, we knew that it only generated $1.2 million and we needed about 1.4 or 2.45. And so so the board committed to transferring that variance, the $1.3 million from general fund to permanent improvement. So that's why when we're looking at this slide and saying, what does it mean to have a replacement levy? We're capturing additional millage. We're capturing additional tax dollars to help offset that $1.3 million transfer.
And go back to the last slide. What's rolling off when?
So this is a chart to show right now in December of 2022 to collect in 23 is 0.75 mils.
Okay.
And then there's just really small millage roll-offs in those smaller years. But then in 2026, we have 0.93 mils rolling off of debt, and then 1.45 in 28.
So we've got a 1.25 levy that's expiring,
Correct.
right? And then we've got another 0.75 rolling off
Correct.
next year.
Correct.
So those two combined, if we were to look to keep things equal, is 2.0.
Correct.
Okay, I just want to make sure that's clear.
Oh, you did. Oh. Relay. So then, as a reminder, this is when you're looking at this chart, the total cost of a replacement, you can see the different amounts. If we just renew the current levy, people would continue to pay $35.88 per $100,000 in home value. That's what they're currently paying. And then if we replace, so instead of doing a renewal, we're going to replace it with either a 1.25, 1.5, 1.75, or 2 mil. You're gaining the value growth. So, we go through reappraisals and updates and your home values are increased, but because of House Bill 920, the 1.25 mil levy is actually collecting it just over 1 mil because that rolls the levy back. So if we replace, you're now capturing that value growth. And so that's why you see, even though a renewal of a 1.25 is $35.88 per $100,000, replacing that is $43.75 because you're now looking at that increase in home value. And it's like a reset when you replace. Then the next column shows what is the current cost of the 1.25 and the 0.75 bond issue. And you can see it's $62.13. So depending on which levy, if we choose to either renew or replace and not let it expire, you can see that you would either have a savings of about $26.25 all the way down to a cost of $7.87 per $100,000 in home value. Again, depending on which of those you would see.
Okay, so if I could summarize then, the last few slides up to this one, at least as I understand it, if we were to keep current millage with the existing PI and the bond that's rolling off, that would be 2 mils.
Right.
If we're to keep existing tax dollars, it would be closer to the 1.75 mils.
Correct.
Okay.
Because of House Bill.
Right.
Yes. Yes.
Just trying to keep myself straight as you go through this.
So I want to remind you of the timeline. We can discuss this all the way up to probably May, June. But we have to have time to pass a resolution of necessity, which basically is the board saying, we think it's necessary to put a levy on the ballot. You can do a couple of those. You don't have to just do one. Then that resolution goes to the county auditor. They certify the numbers that they say, here's what 1.75 mils will generate. They certify and then send that back to us. And then the board if you do one, that's obviously the only one that you would want to move forward. If you decide to do 2 or 3, then you have to decide which one of those would go forward and actually be on the ballot. And that's called a resolution to proceed. And so that has to be filed by August 10th with the Board of Elections. So thinking about our board meetings from now until then, you can kind of see where we're at. We don't have to wait until June to pass those resolutions. We can do them this month and go through all that. It's still not going to be on the ballot until November, but these are like the drop dead dates that we need to have this decision made by. So we need to decide, are we going to renew or replace?
Good slide.
Our recommendation is to put the 2.0 mil 5-year replacement levy on the ballot. And there are several reasons that we think this. It would generate $2.3 million. We need 2.5. So that would reduce the liability to the permanent improvement fund, and those transfers from the general fund could be lower. So we'd still have to send a couple $100,000, but that's less than the 1.3 that we're doing now. It is a minimal net increase to taxpayers due to the bond rolling off, and then a potential to decrease future operating levy millage. As we've talked about several times, and you'll hear me say it during the forecast presentation, right now, it looks like we would probably be looking at an operating levy in 2024. We clearly don't want that to be a large one if we have to go forward. And so if we're not transferring money and taking money from the general fund and transferring it into PI, that obviously is helping. And so if you think about $1.1 million each year for the next 4 years, we're putting $4.4 million back into the bottom line of the 5-year forecast. So that's why Michael and I have decided that we think the 2.0 mil 5-year levy. We also think 5-year because that gives the community every 5 years, you get to decide, the community, are we doing what we said we would do? Are we being good stewards of this money, rather than asking you to just do a carte blanche continuing, which would never come back to the voters. So this is the place where the board gets to discuss and decide which option or options do you want to go forward with as a resolution of necessity. Again, you can do more than one of those. You could say to us, well, we'd have to pass a resolution and it wouldn't be tonight, we bring it back. But you would have to pass a resolution for each option that you want. So if you want to find out 1.25, 1.75, 2.0, any of those, pass that resolution, submit it to the county auditor's office, they would send that back. Again, our recommendation is to submit the 2.0 mil replacement to the county auditor for certification.
You don't have the ability to do a resolution tonight?
I don't have them formally done, so.
It's the legalese has to be precise
Yeah.
In order to go to the auditor. So we would recommend that if we could have the conversation tonight, depending on where you would end and consensus, we could prepare that from a legal perspective for the April 25th board meeting.
Okay. I think this is easy. I mean, we've been talking about this enough. I think we go 2.0. It's what we need for our permanent improvement. We know that there's an operating levy coming, and that $4 million gets us back on the operating is huge to keep the numbers low. That would be my recommendation. I don't really have much more to say.
Oh, we're going in order.
Might as well.
I think that 2.0 is a reasonable request. I think we should also consider the 1.75. So I would like to have both resolutions for further discussion. You know, I just think it's a reasonable conversation to have and to continue that conversation. We clearly need, both numbers will help going forward. Both numbers will get us much of what we need. One is, you know, a tiny tax decrease in dollars. People spend dollars, not bills. So I'm sensitive to the fact that people spend dollars, and in the current inflationary environment, I think we ought to be sensitive to that. So I'd like to have both resolutions for further discussion.
That's fair. Can I add before you jump in? The one thing I do think it's worth pointing out is, you know, we are in the position we're in right now, which is a good position because of the really thoughtful approach. I mean, we talk about this a lot about how we've been really thoughtful about how we manage the finances we have. To have, just think about to have gone as long as we have without an operating levy. We did pass the PI, but we basically subsidized the PI for the last 5 years. And that meant even being even more frugal on the operating side. So I don't think this is all of a sudden, you know, let's just go and start spending like crazy. I think the point though here is, you know, I think we've shown the stewardship that we should. This is now about just making sure that the right dollars are in the right buckets. And so I would want people to know, and I think you're right, we need to have the conversation about 175 or 2, and recognizing that, you know, it's kind of a weird economic world we're living in right now. But I think this is, it's just the right thing to do to identify these dollars and have them in the right place, but also know that it's not going to change how we approach the process of being responsible with taxpayer dollars.
Right. And the PI we have, that was also not a tax increase.
That was a tax decrease.
That was a tax decrease because we had 2.5 mils rolling on. And we asked for 1.25 in permanent improvements. And again, a reminder, permanent improvements are just for things, it's for our facilities. It's for things that have a life of a
Greater than 5 years.
Greater than 5 years, right? So that's all it's for. That's all we spend the money for. That's what the law says. That's what we do. So, yep, okay.
Not much to add. I was going to suggest that we also include the 1.75. I think it's a appropriate conversation just with everything going on in the world and the economy and within our community. Just a quick question though, Becky. So the 2026 bond roll off, that's $32 per 100,000. If we really look over the life of the 5 years though, we would still actually be giving back a little bit. It's a little bit, but still.
Could we get those numbers? So over the 5-year period to see what the total is over the 5-year period?
But I do think the goal is just to figure out, to John's point, how do we do the best job possible to make sure that the dollars are in the right bucket while continuing to be very vigilant with our fiscal responsibilities and doing what's right for, you know, the local taxpayers. So I think we have the right two options, in my opinion.
I think to echo what John, Phil, and Mike have all said, first going back to, what has it been, since 2013, since we've had a operating levy? 12. It's been 10 years. We're not doing an operating levy here. We've talked about maybe 2024. But again, to reiterate Phil's point, the last time we did the PI, we did 0.75, and it was at a time that 0.75 was rolling off. So we've had, that's 10 years by my book, right? We've got no new PI and no new operating levy in 10 years. I think, as Mr. McClellan said, it's a testament to a lot of the activity that's been going on, and Ms. Jenkins, all of your efforts relative to our financial policy, but also taking a long-term view of where we are. So I have two things to say. One, I can get behind, and I agree that we should look at the 1.75 as well as the 2 to have the discussion. But I do think that we also, as we go about our decisions in the coming months, need to take into account thinking through and doing the analysis on what do we have beyond the PI, what do we have beyond the operating levy to accommodate the facilities needs for our students going forward. I just think we need to have that conversation relevant to the expectations of our residents moving forward.
So it sounds like we're gonna go forward with both options. Becky, if you go back, or Michael, one slide. For all those reasons, I am supportive of the 2 mil option. I think I like the idea of getting the money in the right buckets and as much as possible to reduce the liability to the 5-year forecast. But certainly both options are reasonable. So we will have resolutions for the 2 options at the next meeting.
Correct.
Okay. Any further
Continue to-
discussion, or?
You can continue, like you pass those resolutions, you could still discuss,
Okay.
and then we would know what you want to do for the May 16th meeting.
Okay.
If you're ready, if that conversation is enough for the board to feel comfortable with what they want to do going forward.
Any other comments or discussion? Okay. All right, we will move on now to the first reading of our 5-year forecast. Ms. Jenkins.
Thank you. So just as a reminder, we have to file an original 5-year forecast by November of each year, by the end of November each year, and then we have to file an update between April 1st and May 31st each year. So this is just an update. The original, I would say, is probably the most important one that we do each year, but then this is our update. And again, statement of purpose absolutely drives everything we do, including these financial decisions that we make. So just to look at the current fiscal year, what we did in November versus what I have for you in May. Almost all of our revenue has been received at this point as of the end of March. We have about $1 million, just almost $1.1 million more collected in revenue than we had anticipated. And I will tell you the majority of that was delinquent tax collections. We had about $1 million more than what we had anticipated in that. My guess is either something large sold and so the delinquent tax was paid, or someone decided to pay their delinquent tax, but it was on a larger property, not just like a lot of them.
$1 million tax on a single property?
Well, it's not, it's probably commercial.
Okay.
Yeah. And then expenditures, I have reduced personnel and benefits because we had 4 classified and new hires and 2 certified new hires that we did not hire. And then the turnover savings that we have usually every year. So those 2 things in those 2 line items that we reduced by $831,000. I expect that by the end of the year, a lot of our other expenditures, especially in purchase services, will be lower. But until I'm sure what's happening with state aid, there are some expenses that come out of state aid that aren't. I was reluctant to reduce those yet. So in total, $1.9 million positive variance in the impact to the 5-year forecast. So what does that mean if the current fiscal year is $1.9 million better between revenue and expenses? It means that you look at the first circle that's up there, we are still projecting a deficit spending in the current fiscal year, but that was $2.1 million in November, down to $255,000 now. As I said, I do expect some of our other expenditures to be lower. And so I believe we will end the fiscal year with a balanced budget. That will not be a negative there. And then that rolls through the forecast, and we have a $6.3 million ending cash balance at the end of 2026, as opposed to $3.7 million, which is what we had projected in November. So just as a recap, state aid, so we have a new funding formula. We talked about this in November. We are still getting details of some of those calculations that they put into place because it's a completely different formula. We have enough to be able to project what we think our state aid will be next year, but the difference between how ODE is putting the formula together based on the law that was passed versus the LSC simulations that came out from the legislators when they were going through the process, we look like we are getting about $408,000 less than what those LSC simulations said. So the problem is nobody has, ODE doesn't have, no one has the detail behind what the LSC simulations were calculated on. So I don't know why. I do know that we have about 3 areas in the formula. Transportation was far reduced. Student wellness and success, we were receiving $239,000 for that because it's now part of state aid calculation, and subject to the phase-in, we dropped down to $69,000. And then but those are the 2 largest areas. So yeah, so not getting as much money as we thought we were going to get in November based on this. And again, still looking, I think the April, so we get 2 payments from the state each month. So the April number 2 payment should have a better breakdown of what is happening with state aid for us. Real estate collection, I already said, large delinquent real estate tax payment was received. Income tax sharing with the city of New Albany is higher than what they expected it to be. And we'll look at finances at our next board meeting, but I took a look at our financials for March, and we're about $700,000 over collected for the year. The current month, March, was about $70,000 less than what we expected. So we'll see how it plays out, but I don't think that there'll be that much of a difference between now and June. Overall, our revenue is within 1.5% of our projections to date. Expenditures, again, salaries and benefits were reduced based on those positions that were not filled. And I know I say this every time we do these meetings, but Michael and his team are very, very diligent about their hiring, and no position is hired unless there's a justification for it. And Michael can be kind of tough in some of those meetings. So definitely there's a process for that. If capital outlay is not spent, which I don't expect that it will be, we will transfer those funds over to permanent improvement, because capital outlay is for similar kinds of expenditures as permanent improvement. And we have the need, clearly, we've just had that conversation, so we'll transfer those funds in June. We do still begin to deficit spend in the current fiscal year, but again, I believe that and at the end of the day, when we close our books in June, we will not have a deficit expenditure there. Fiscal 26 ending cash is projected still to be positive, which is very good based on those revenue and expenditure positive variances. We do have the PI levy. I won't go into any more detail on that one. Right now, if you're looking at the 5-year forecast, you would look at that and say, potentially, we need an operating levy in 2024. I don't know the millage because we'll have to have a lot of discussion. First of all, we need to get closer to that because we're going to have more positive variances, hopefully. The state doesn't do anything crazy with funding. But once we get closer to that, we'll be able to decide whether we do or don't need to go forward and what that millage amount is. But right now, looking at what the forecast looks like, you would think that we would be on the ballot in November of 2024 for some kind of operating levy. Happy to answer any questions.
Just to clarify that need, what is the state law requirement in a 5-year forecast? We're not allowed to have a 5-year forecast that has a negative balance, are we?
In the first 5 years.
Right.
Well, you can have one, but then the state's going to reach out and say, you can't have a negative balance in the current year.
Right.
The future years could have a negative balance, but the Department of Education is going to send something out to me and say, you have a negative cash balance within the first 3 years of your forecast. What's your plan to get rid of it?
The ending cash balance, the bottom line.
Yes.
Right.
yeah, not the
Just want to
deficit spent.
clarify, it's the
Yeah.
ending cash balance at the bottom that's now 6.3. That has to
Positive.
be
5 years.
positive.
Right,
Correct.
they're not really looking at the 6.01 where we're deficit spending in the current year,
Right.
which I think is the most
bottom line.
important, right? At the very bottom line, if there's a negative ending cash balance in the first 3 years, then you're gonna get a notice from ODE, and it is a very, very detailed explanation. You know, way back when you could say, well, we're gonna put a levy on a ballot, we're gonna make some cuts, and that was enough. And now they wanna know what is that levy? And then if that doesn't pass, what are the positions? What are the cuts? What are you doing to delete it? So you can have a negative cash balance, not in the current year, but in the out years, but
There's a lot of work that comes with this.
Okay, so taking this as it is and looking at the trends, even with continued positive variances at the rate they've been coming, it's likely that 2027 is going to have a negative cash balance, right? If we were to put a levy on the ballot in November 2024, when would we start? I know these are conversations to go then, but I still want to set the table. When would we start collecting money for that?
January of 2025.
Okay, so that means there'd be the budget that's currently showing for 2025 is going to be pretty close to what it would be, even if we put put a levy on the ballot in 2024.
Yes,
Pretty
because
close.
yes, because you're only going to have a half a year of collection in that first year of whatever
Whatever
you
it is.
put on. You know, you could put the ballot on in May and you don't collect until January.
Okay.
And you're only collecting half of a fiscal year.
So just trying to, again, set the table for this timing. Why you're talking about 2024 is because there's a year lag before you start collecting. We're going to be within 2 years of a negative cash balance, which is going to require something. So just trying to make sure.
It's being proactive that you're attempting to collect a lower millage amount 2 years prior to actually completely being in the
Underwater.
red. So you don't have to have a crisis, and that's really what I'm going to call it, a crisis like happened here in 2014-15, because 8.9 mils was on the levy and we had to cut 100 positions across the school district because we waited until the very end to go after it. We can go for a lower millage amount sooner and still remain good stewards and fiscally responsible, but to offset that deficit that you're seeing will be a complete deficit by 27.
Well, so you've just, maybe without knowing it, you've just painted a picture to John's point about, what we've accomplished over the last 6 years. Our last levy was 2012, right? That passed.
The last successful.
The last successful levy.
That passed,
Yeah.
right? So 10 years now, it'll be 12 years till we're saying we're probably going to need new money. But we failed the levy in 2014. And so we've been operating, and that levy, based on how the district was operating at the time, that levy was needed, right? But we've changed a lot about how we're operating. Our statement of purpose, we talk about it and we make a big deal about it, but it has guided the conversations that Ms. Jenkins just said you have with your staff when there's an open position, right? Is this in the best interest of kids? Does this help us accomplish what we said we're here to do? And so we're spending money where it matters for kids. And that's why, because of all this work, because of the clarity of purpose, because of the work behind the scenes to make it real, we've extended this levy for 10 more years. I mean, it's a pretty big deal.
Which candidly is unheard of.
I know.
I mean, honestly, because we get phone calls asking us, and administrators are all shaking their heads because they will tell you, we've come from other walks of life. This is not normal when it comes to school finance because of the over-reliance on property tax that's the burden on the taxpayer because it doesn't come to us from the state.
Especially in a fast.
Yeah, but the work that this team has done is not normally what you see in most school districts. It just isn't.
I would say too, that's the importance of the CIP goal that the board sets and that there is a financial goal, because the sooner you can make reductions that are compounding, the bigger the impact is to the 5-year.
Without
forecast.
sacrificing results and
Yes.
programming to meet the needs of kids, both academically and developmentally, back to your point about the statement of purpose. And that's the commitment that this team has made. And I think we produce it every day.
Right, so everybody here has, compensation at risk for our academic goals. And you and your team have some money at risk for our financial goals as well as the academic goals. So, it's working.
It's hard, but it's right.
Agreed.
I don't think anyone wants to go back to
No,
No.
never,
2014 again.
never, ever again.
Well, that was our promise to solve the boom and bust cycles that we were saddled with here. And so I think it's been great work.
All right. Thank you. With that, next on our agenda is board policy, Superintendent Sawyers.
President Kalinowski, members of the Board of Education, we are in full steam ahead for 2022-23. So the policies that are appearing tonight have updates from state statute, federal statute, or recommendations the administration is making in preparation for the updating of student handbooks, codes of conduct that will happen in the summer, as well as staff handbooks and policy. So I can answer specific questions related to them, but that's really the 10,000-foot view of them. There's a couple things that happen on the federal side that codify new definitions for weapons and food service and procurement responsibilities for grants for language that was passed as part of federal legislation. All that's now hit the books from Neola. So those appear tonight in addition to the recommendations we're making that'll help prepare us for summer changes to handbooks that eventually will come back to the Board of Education full circle for approval.
Okay, next on our agenda, may I have a motion and a second to approve superintendent's items A through B, please?
So moved.
Mr. Darrow and Mr. Bush, Superintendent Sawyers.
Thank you, President Kalinowski, members of the board. The personnel action items this evening are standard. I'm going to call your attention to three things because it's really end of the year stuff. And then we start turning the page to prepare for 2022-23 and our next school year. So tonight we accept the resignation for another retirement for custodian in our school district, George Anderson. Just as a reminder for board purposes and the public, we will do a staff retirement reception at your May 16th board meeting. We'll make sure we continuously remind you of that, but we'll do reception for, we currently have 4 retirements that are currently known across the school district that you previously have acted on once you adopt the resignation for George this evening. In addition to that, also in preparation for the next school year, tonight we start personnel action items for administrators. April is Administrator Month, and non-teaching exempt non-teaching employees will also be on the next agenda. But tonight we congratulate Dr. Jessica Mamayas and her transition to become Director of Secondary Education in the school district, and the appointment of Katie Nowak, Catherine Nowak, currently intermediate school principal, who's becoming the Director of Assessment and Accountability effective August 1st in the school district. We are currently actively seeking the replacement for Mrs. Nowak through the posting process. So we're accepting applications for the new intermediate school principal, and hopefully we'll have a recommendation for that appointment at the May 16th board meeting. For general business this evening, standard action items, call your attention to one thing, and it's really in preparation for next year because we have families asking us. And you'll recall this from the last Board of Education meeting, you adopted summer rates related to Eagle's Nest. Tonight, we're actually recommending the tuition rates necessary for the 2022-23 school year so that we can start the registration process and tell families what the tuition will be for the before and after school care program for our elementary students in grades pre-K through, or excuse me, kindergarten through 5th on general business. Happy to answer any questions you may have.
Congratulations. We're excited at both of your new appointments. Any questions? Ms. Jenkins, please call the roll.
One quick question.
Sure.
Can you share any insight on this Zimmerman school equipment?
Yeah, you may recall 6 years ago, We purchased cafeteria furniture on the middle school side of the cafeteria with cafe styles. So some of those tables and chairs have just are in such disrepair. And the work associated to putting them in and taking them out for different events, we're going to transition based upon the disrepair to cafeteria rounds. So we're ordering the additional cafeteria tables that would be necessary to replace that furniture. And then we're working with companies to get quotes to actually purchase some of the chairs and tables that are still usable for resale purposes so that we can actually exchange them to offset our costs associated to the cafeteria rounds.
We did get several quotes for these and it will be paid for out of the food service fund.
All right, Ms. Jenkins, please call the roll.
Mr. Darrow?
Yes.
Mr. Bush?
Yes.
Mr. McClellan?
Yes.
Vice President Newmaw?
Yes.
President Kalinowski?
Yes, and the motion carries. That brings us to adjournment for this evening. May I have a motion and a second to adjourn our meeting? Mr. Darrow and Mr. McClellan. Ms. Jenkins, please call the roll.
Mr. Darrow?
Yes.
Mr. McClellan?
Yes.
Mr. Bush?
Yes.
Vice President Newmaw?
Yes.
President Kalinowski?
Yes, and the motion carries. Our next meeting is on April 25th at this location at 6 p.m. Thank you very much.